Before we begin, a quick and important disclaimer. The following content is provided for educational and entertainment purposes only and does not constitute professional legal, theological, or psychological advice. Islamic law and American civil law regarding domestic relations are incredibly complex, nuanced, and subject to varying interpretations across different jurisdictions and schools of thought. This video does not establish a consultant-client relationship. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified legal professionals, licensed therapists, or recognized religious authorities regarding their specific personal situations. In the United States, we often view divorce through the lens of a failed romantic contract or a bureaucratic dissolution of assets. But what if I told you that in one of the world's fastest-growing faith groups in America, divorce is framed not just as a tragedy, but as a regulated, legally structured safety valve that sociologists are now studying as a model of social pragmatism? There is a profound paradox at the heart of the American Muslim experience. Islamic scripture describes divorce as the most hated of all permissible things to the Creator, yet the legal framework for it was established over 1400 years ago with a level of specificity that would make a modern prenuptial attorney blush. Today, we are peeling back the layers of a topic often shrouded in cultural taboo and Western misconception. We are diving deep into the American sociological views on divorce in Islam. By the end of this masterclass series, you will understand how the intersection of ancient religious law and modern American civil statutes is reshaping the domestic landscape of the 21st century, solving the problem of cultural illiteracy, and providing a roadmap for understanding how faith-based communities navigate the high-stakes reality of marital breakdown in a secular society. To understand divorce in an Islamic context from a sociological perspective, we first have to look at the American landscape. For decades, the dominant narrative in U.S. sociology regarding Muslim communities was one of total assimilation or rigid isolation. However, recent historical trends suggest a third path, a sophisticated blending of identities. When we look at the potential outcomes of a marriage in the American Muslim community, we see a fascinating interaction between the nikah, or the Islamic marriage contract, and the civil marriage license required by the state. In the American view, marriage is often seen through the lens of expressive individualism, the idea that a relationship exists primarily for the personal growth and happiness of the individuals. When that happiness fades, the social contract is considered broken. Sociologically, Islam presents a communal contractual model. The marriage is not just a bond between two people, but a contract between families, often mediated by the community, and governed by a set of codified rights and responsibilities that exist regardless of the emotional state of the participants. Consider the sociological concept of social capital. In many American Muslim enclaves, from the suburbs of Detroit to the urban centers of New Jersey, marriage acts as the primary vehicle for building social capital. When divorce occurs, it is not just a private matter. It is a structural shift that affects the entire community's network. American sociologists often apply structural functionalism to this phenomenon. This theory suggests that every part of a society, including the rules surrounding the end of a marriage, serves a function to keep the society stable. In the Islamic framework, the waiting period known as iddah serves a profound sociological function. It is a mandatory 3-month cooling-off period after a divorce is initiated. From a data-driven perspective, this serves to prevent impulsive decisions, ensure the clarity of paternity in the event of pregnancy, and provide a window for reconciliation. In a fast-paced American culture where quickie divorces are a trope, the sociological function of the iddah is seen as a mechanism for social stability, preventing the sudden displacement of women and children from their support systems. However, we cannot discuss this without looking at conflict theory. This sociological lens focuses on the power dynamics within a group. In the context of Islamic divorce in America, conflict theorists point to the disparity between talaq, the husband's right to initiate divorce, and khula, the wife's right to initiate divorce. While the theological ideal emphasizes equity, the sociological reality in a U.S. context can be different. Because American Muslims live under a dual legal system, a woman might be civilly divorced under U.S. law, but still considered religiously married within her community if the husband refuses to grant a religious divorce. This creates a state of marital limbo, a unique sociological condition that researchers are documenting with increasing frequency. Case studies in major metropolitan areas show that this led to the rise of Sharia councils and community mediation boards that attempt to bridge the gap between religious requirements and civil realities. These boards act as a shadow judiciary, providing a sociological service that the state courts cannot. The provision of religious closure and community legitimacy. We also have to examine the role of the mahr, or the mandatory gift from the groom to the bride. To the uninitiated American observer, this might look like a dowry, but sociologically, it is the exact opposite. It is a form of financial autonomy and a social security mechanism. Historical trends in Islamic jurisprudence show that the mahr is often divided into an immediate payment and a deferred payment. The deferred portion is typically due only upon divorce or death. In a sociological sense, this creates a significant financial exit cost for the husband, which serves to disincentivize arbitrary divorce. In the US, we are seeing more and more secular courts having to decide whether to enforce these Islamic marriage contracts as valid prenuptial agreements. This is where the sociological meets the legal. Is the mahr a religious ritual, or is it a binding financial contract? The potential outcomes of these court cases are redefining the boundaries of religious freedom and contract law in America. Data from organizations like the Family and Youth Institute suggest that the divorce rates among American Muslims are beginning to mirror the general U.S. population, hovering around 30 to 40%, depending on the specific ethnic subgroup. This is a massive shift from 30 years ago. Sociologists attribute this to acculturation, where the second and third generations are adopting Western views on individual rights and the social acceptability of divorce. Yet, the way these divorces are handled remains distinctly influenced by Islamic principles. For instance, the concept of ihsan, or excellence and kindness, is frequently cited in sociological interviews with divorcing Muslim couples. The Quran mandates that if a couple is to part ways, they must do so with kindness. This creates a sociological expectation of collaborative divorce that predates the modern American legal movement of the same name. As we move forward in this deep dive, we have to address the open loop of the social stigma. Despite the legal frameworks that allow for divorce, the sociological stigma remains a powerful force of social control. In many immigrant communities, the fear of shame acts as a deterrent more powerful than any legal statute. We will explore how the digital age and social media are breaking these taboos, creating divorce support groups for Muslim women that never existed before. We are witnessing a revolution in how a traditional faith interacts with a hyper-individualistic society. This is not just about the end of a marriage. It is about the evolution of a community trying to maintain its soul while navigating the complexities of the American dream. Stay with us as we move into part 2, where we will break down the specific legal mechanisms of talaq and khula, and how they are being reinterpreted by a new generation of American imams and legal scholars to ensure justice in a modern world. This is the intersection of faith, law, and the human heart. To truly grasp the mechanics of divorce in an Islamic context within the United States in 2026, we must first dismantle the Hollywood-style caricature of the instant divorce. In the sociological landscape of modern America, divorce is not a singular event, but a multi-stage process that involves a complex negotiation between theological mandates and civil requirements. Let's start with the most misunderstood mechanism, talaq. While often portrayed in popular media as a man simply uttering a word 3 times to end a marriage, the sociological reality in the American Muslim community is far more rigorous. Imagine a scenario in 2026. We have Michael, a professional living in Dearborn, Michigan, and his wife Amina. Under the guidance of modern American imams who are increasingly integrated into the social sciences, Michael cannot simply walk away. In the eyes of the community and the religious scholars they consult, a talaq initiated in a moment of anger or intoxication is often considered invalid. Sociologically, this represents a movement toward effective stability. Historical trends show that American Islamic jurisprudence has largely shifted toward the view that 3 pronouncements of divorce in one sitting count as only one, providing a structural buffer against impulsive decisions. This is a critical point. The law is designed to slow the process down. Michael is required to initiate a sequence that involves mediation, often with a licensed family therapist who understands both the psychological and the spiritual stakes. This is where the sociological concept of social integration comes into play. The community acts as a stabilizing force, attempting to repair the bond before the legal ties are severed. But what happens when the power dynamic shifts? This brings us to khula, the right of the woman to initiate the dissolution of the marriage. Imagine if Amina is the one who realizes the marriage is no longer viable. In the year 2026, Amina has more resources than ever, but she still faces a unique sociological hurdle. Under the traditional framework of kula, the wife typically returns her mahr, or dowry, in exchange for her freedom. From a sociological perspective, this is a form of contractual reciprocity. Case studies from legal clinics in New York and Chicago show a fascinating trend. American Muslim women are increasingly using their mahr as a strategic asset in civil divorce negotiations. If Amina's mahr was set at $40,000 in her original nikah contract, she might agree to waive that religious debt in exchange for a more favorable distribution of their civil assets, like the equity in their home or Michael's 401k. This is a masterclass in how religious law and civil law are not just parallel tracks, but are actively intersecting to create new potential outcomes for financial settlements. Now, let's look at the third and perhaps most vital mechanism for the protection of women: fash. This is a judicial divorce granted by a religious authority, even if the husband refuses to cooperate. Sociologically, fash acts as a safety valve against marital captivity. In 2026, we are seeing the rise of Sharia councils in the U.S. that function as non-binding arbitration boards. These boards, often comprised of both religious scholars and legal experts, step in when there is evidence of abuse, neglect, or abandonment. Consider the case study of a woman we'll call Jessica, who converted to Islam and married a man who subsequently disappeared, leaving her in a legal and social limbo. In a purely secular context, she would file for a divorce by publication. But for her community to recognize her as single and eligible for remarriage, she needs a fash. The council conducts a fact-finding mission, essentially acting as a sociological investigator, to determine if the fundamental rights of the marriage contract have been violated. This process provides the individual with psychological closure and social legitimacy, which are often just as important as the legal decree from a state court. The sociological impact of the iddah, or the waiting period, also deserves a deep dive. While we touched on this previously, the 2026 American view of the iddah has evolved into a period of mandatory transition. It is not merely about checking for pregnancy. It is a period where the husband is religiously obligated to provide housing and maintenance for the wife. In the U.S., this often creates a conflict with the civil concept of temporary orders in a divorce case. Sociologists studying these interactions find that the iddah serves to prevent spousal shock, the sudden financial and emotional collapse that often follows a separation. By mandating a period of cohabitation or continued support, the Islamic framework forces a level of civil interaction that can, ironically, lead to more amicable settlements. It turns the open loop of the breakup into a structured, time-bound phase of social reorganization. We also have to discuss the role of symbolic interactionism within the American mosque. For many couples, the imam is the first point of contact when things go wrong. In 2026, the professionalization of the imamate is a major trend. Imams are no longer just prayer leaders. They are being trained in domestic violence prevention and conflict resolution. When a couple walks into an imam's office in Virginia or California, they aren't just getting a lecture on theology. They are entering a sociological intervention. The imam uses the religious text as a framework to address modern issues like social media jealousy, financial infidelity, and the pressures of the sandwich generation, caring for both children and aging parents. The potential outcomes of these interventions are shifting the data on Muslim divorce. While the rate is rising, the success rate of mediation is also increasing, because the religious incentive to part with kindness provides a powerful motivation that purely secular mediation sometimes lacks. However, a massive sociological tension exists regarding the enforceability of the nikah in U.S. courts. This is where the theory of legal pluralism becomes essential. American courts are generally hesitant to get involved in religious questions, but a nikah is, at its core, a contract. In 2026, we are seeing more cases where judges are being asked to enforce the mahr as a prenuptial agreement. If a contract says the husband owes the wife $50,000 upon divorce, is that a religious penalty, which the court won't touch, or a civil debt, which it will? This creates a high-stakes legal environment. If the court rules it's purely religious, the woman may be left without the financial protection she bargained for. If the court rules it's civil, it risks violating the Establishment Clause of the First Amendment. This sociological and legal gray zone is where some of the most intense battles for identity and rights are currently being fought in the American justice system. As we look at the data, we see that the second generation of American Muslims, those born and raised in the U.S., are redefining these terms. They are more likely to insist on detailed, written nikah contracts that include clauses for professional mediation, clear definitions of mahr, and even stipulations regarding the wife's right to work or her right to initiate divorce without returning the mahr in cases of specific misconduct. This is a move toward empowered agency. They are taking the 1,400-year-old framework and optimizing it for the 2026 American reality. But what happens when these two worlds, the religious and the civil, collide head-on in a way that leaves one party completely vulnerable? What happens when a civil judge's ruling directly contradicts an imam's religious decree? In the next part of this masterclass, we are going to explore the dark side of this intersection. The phenomenon of aguna-like situations in the Muslim community, where women are civilly free but religiously chained, and the radical new solutions being proposed by American activists to break these bonds once and for all. You won't want to miss the sociological breakdown of the modern Kula movement and how it is shaking the foundations of traditional authority. Stay tuned for Part 3. To understand the current tension in 2026, we have to look at the sociological concept of marital captivity. This is a state of liminality, a social in-between, where an individual is no longer functionally in a relationship but remains legally or religiously bound by it. In the American Muslim community, this has historically manifested as women being civilly divorced under United States law, but religiously shackled because their husbands refuse to grant a religious divorce. From a sociological perspective, this creates a subclass of individuals who are effectively excommunicated from the dating and remarriage market within their faith. They are the chained women. Imagine Sarah, a 32-year-old software engineer living in Dallas in 2026. Sarah finalized her civil divorce 2 years ago. Under Texas law, she is a single woman. She has her decree, her assets are divided, and she has joint custody of her children. However, in the eyes of her local religious community and her family back in her ancestral home, she is still married. Her ex-husband, utilizing the religious framework as a tool of post-separation abuse, refuses to pronounce the religious divorce. This is what sociologists call the strategic use of tradition. By withholding the religious dissolution, he prevents her from moving on spiritually and socially. If Sarah were to remarry without a religious divorce, she would be seen by many as living in a state of constant sin, a label that carries immense social weight and can lead to the loss of her social support networks. This phenomenon has sparked what researchers are calling the modern Kula movement. In 2026, this movement is not just a theological debate, it is a full-scale sociological restructuring of authority. Historically, the power to dissolve a marriage rested almost exclusively with men or with male-dominated religious councils. But a new generation of American Muslim activists, lawyers, and female scholars, often referred to as alimat, are challenging this monopoly. They are utilizing the concept of public interest, or maslaha, to argue that the systemic entrapment of women is a greater harm to the community than the unconventional granting of a divorce by a third party. Step by step, this movement is implementing a standardized nikah across the United States. This is a sociological intervention disguised as a legal document. One of the most critical components being pushed in 2026 is the inclusion of a clause known as tafwid al-talaq, or delegated divorce. From a sociological standpoint, this is a radical redistribution of power. In this contract, the husband delegates his right to divorce to the wife at the time of the marriage. This means that if certain conditions are met, such as domestic violence, failure to provide, or even a civil divorce being granted, the wife can essentially divorce herself religiously. Case studies from the greater Chicago area show that mosques that mandate this clause in their marriage contracts see a significantly lower rate of marital captivity cases. The data suggests that by equalizing the exit costs and powers at the beginning of the marriage, couples are forced into a more egalitarian dynamic throughout the relationship. However, the resistance to this change is a prime example of institutional inertia. Many older, first-generation imams view these clauses as a westernization of the faith that undermines the traditional family structure. Sociologists observe a clear generational divide here. While the younger, U.S.-born population sees the standardized nikah as a tool for justice and protection, the older generation often views it as a divorce-ready contract that encourages the breakdown of the home. This creates a fascinating sociological mapping of authority. In 2026, we see American Muslims mosque shopping based on how progressive or traditional the local imam's views are on divorce. A couple might live in a neighborhood with a conservative mosque, but travel 30 miles to a different community to sign a contract that offers more protections for the bride. The role of technology in this sociological shift cannot be overstated. In 2026, digital accountability has become a powerful tool. When a husband refuses to grant a religious divorce despite a civil decree and clear evidence of harm, he no longer operates in the shadows. Private Facebook groups, WhatsApp communities, and even review platforms for community members are being used to highlight these cases. This is a form of social shaming as a mechanism for justice. While controversial, sociologists note that in the absence of a formal, centralized religious court system in the U.S., these digital networks act as a decentralized judiciary. The potential outcomes of being called out in a digital community are severe: loss of business connections, social ostracization, and pressure from family members. It is a modern high-tech version of the ancient village square, repurposed for the protection of individual rights. We also have to analyze the transnational sociological effect. Many American Muslims are part of a diaspora with deep ties to countries where Islamic law is the law of the land. When an American court grants a divorce, but a religious council in another country does not recognize it, it creates a transnational limbo. This is particularly prevalent in 2026 due to the ease of global communication. A woman in Virginia might find herself unable to visit her grandparents in another country because her husband there could legally prevent her from leaving, claiming they are still married. This leads to a complex legal pluralism, where individuals must navigate 3 or 4 different legal and social systems simultaneously. To combat this, American Muslim legal organizations are working on harmonization strategies. They are creating legal bridges between U.S. civil law and international religious interpretations. For example, some activists are pushing for U.S. civil judges to include religious dissolution requirements as part of the civil settlement. Imagine if a judge in California, as part of a divorce decree, orders the husband to provide the religious divorce papers or face a fine for non-compliance with the good faith spirit of the original marriage contract. While this enters a thorny area of constitutional law regarding the separation of church and state, it represents the lengths to which the community is going to solve the problem of captivity. The data from 2025 and early 2026 indicates that when women have access to religious literacy, meaning they understand their rights under Islamic law, rather than just cultural traditions, the power dynamic shifts. Sociologists call this cognitive liberation. When a woman realizes that her faith actually provides her with exit ramps that her specific cultural upbringing might have hidden, she is more likely to seek a healthy resolution, rather than staying in a toxic environment. This education is being delivered through podcasts, YouTube series, and university-level seminars, creating a better-informed, sociological agent. But as women gain more agency and the movement for reform grows, a new conflict is emerging on the horizon. It's a conflict that strikes at the very heart of the American family unit: the battle for the children. In traditional interpretations, custody and guardianship are strictly defined, but in the American sociological context, these rules are being challenged and rewritten in ways that would have been unimaginable a decade ago. How do you balance best interests of the child in a U.S. court with divine mandates of guardianship? In the next part, we are going into the high-stakes world of custody, guardianship, and the American Muslim child. We will look at how the 2026 co-parenting revolution is clashing with ancient traditions, and what happens when the right to parent becomes a battlefield of faith. You will see why the most heated debates aren't about the husband and wife at all, they are about the next generation. Stay tuned for part 4. When we talk about children in the context of an Islamic divorce within the United States in 2026, we are stepping into a territory where 2 distinct philosophies of child-rearing collide. To understand the sociological tension, one must first master the distinction between 2 Arabic terms that define the parent-child relationship: hadhana and walaya. In the American civil system, we typically use the terms physical custody and legal custody. However, sociologists studying American Muslim families in 2026 have observed that applying these Western labels to Islamic concepts often leads to profound legal and emotional friction. Hadhana refers to the right of nurturing or physical care. Historically, and in many traditional interpretations, this right is primarily vested in the mother. The sociological logic was that during the early years of development, the mother is best suited to provide for the physical and emotional needs of the child. Walaya, on the other hand, refers to legal guardianship. This includes the responsibility for the child's education, religious upbringing, and financial maintenance. Traditionally, walaya remains with the father regardless of who has physical custody. In the year 2026, this bifurcated model is facing a massive challenge from the United States judicial standard, known as the best interests of the child. Imagine a scenario involving David and Fatima, a couple living in Columbus, Ohio. They are going through a divorce in 2026. Fatima, following a traditional understanding, expects that she will have full physical custody, Hannah, of their 3 children, ages 4, 6, and 8, until they reach the age of discretion. David, however, has been an active, hands-on father in the American suburban sense. He wants 50-50 joint physical custody, a common potential outcome in Ohio's family courts. From a sociological perspective, David is operating under the modern American paradigm of egalitarian parenting, while Fatima is seeking the stability of a gender-defined role that she believes is mandated by her faith. This creates a clash of structural functionalism. In the traditional Islamic social structure, the father's role as the guardian, the wali, means he is the one who signs the school forms and decides on medical treatments. If David and Fatima were in a strictly traditional society, Fatima would raise the children day to day, but David would hold the ultimate legal authority. In 2026 America, this is almost impossible to implement because U.S. courts favor joint legal custody, where both parents have an equal say in major decisions. Sociologists are documenting a rise in what they call hybrid parenting plans. These are legal documents crafted by American Muslim lawyers that attempt to satisfy both systems. They might designate the mother as the primary nurturer for certain years, while explicitly granting the father the rights of guardianship that the civil court recognizes as joint legal custody. Step by step, the conflict often intensifies when we look at the historical trends regarding the age of transition. In many classical schools of thought, a boy remains with his mother until he is 7 or 8, at which point he moves to the father's household to learn trade and social responsibilities. A girl might stay with the mother until puberty or marriage. In 2026, these age-based transitions are viewed by American sociologists as highly problematic. A U.S. judge will rarely, if ever, order a child to move from one parent to another simply because they hit a specific birthday. Case studies from California show that when fathers try to enforce these traditional age-based transitions in civil court, they are almost universally rejected, unless there is a specific written agreement that meets the best interests of the child standard. Another major sociological friction point is the remarriage clause. In traditional interpretations, if a divorced mother remakes, she may lose her right to Hannah, or physical custody, of her children from the previous marriage. The sociological intent was to ensure the child was not raised by a stepfather, who might be indifferent to their needs. However, in the U.S. in 2026, this is one of the most contested areas. For a modern American woman, this feels like a marriage penalty. Imagine if Fatima wants to move on and marry someone else, but she knows that by doing so, she risks David filing for a custody modification based on religious precedent. Sociologists point out that this creates a massive incentive for mothers to avoid remarriage or to keep their new relationship secret, which leads to a breakdown of social transparency within the community. In response, a growing number of American imams and scholars are issuing fatwas, religious legal opinions, stating that in the American context, the mother does not automatically lose custody upon remarriage if the new environment is safe and stable for the child. This is a prime example of adaptive jurisprudence. The community is prioritizing the sociological stability of the mother-child bond over a literalist interpretation of historical texts. We must also analyze the financial side of this equation, known as nafaka. In the Islamic view, the father is 100% responsible for the financial maintenance of his children. This is not just a suggestion, it is a legal debt. Even if the mother is a high-earning CEO in Silicon Valley, the father is still obligated to pay for the children's food, clothing, housing, and education. In the United States, child support is calculated using a formula based on both parents' incomes. This creates a fascinating sociological dynamic. Many American Muslim mothers find that the Islamic requirement of nafaka is actually more protective than the state's child support guidelines, especially if the father is wealthy. Conversely, if the father has a low income, the Islamic system might be more lenient, focusing on his ability to provide according to his means. In 2026, we see many couples using the Islamic standard as a floor for child support, rather than a ceiling. They might agree to the state-mandated amount in their civil decree, but have a separate, private agreement where the father covers additional costs like private Islamic school tuition or Hajj savings for the children, fulfilling his role as the religious guardian. Data from the American Journal of Islamic Social Sciences suggests that when custody battles are framed through a religious lens, the level of litigation increases. This is because the parents aren't just fighting for time, they are fighting for the perceived moral high ground. This brings us to the concept of religious continuity. U.S. courts will often defer to the status quo regarding a child's religious upbringing. If the children have been raised as Muslims, the court will generally order that this continuity be maintained. However, if one parent becomes less observant or leaves the faith after the divorce, it creates a sociological firestorm. Imagine if David, after the divorce, stops practicing Islam and wants to take the children to a different religious service during his weekends. In 2026, the potential outcomes for such a case depend heavily on the specific language in the nikah and the parenting plan. Sociologists are seeing a surge in religious upbringing clauses in marriage contracts, where couples agree in advance that regardless of their personal faith journey, the children will be raised in a specific tradition. This is a strategic move to preempt the state court from making a decision that might be seen as a violation of religious freedom. As we peel back these layers, we see that the battle for the children is actually a battle for the future of the community's identity. The ways American Muslims handle custody in 2026 are setting the stage for how the next generation will view the relevance of faith in their private lives. But there is a deeper, more shadow-filled corner of this discussion that we haven't touched yet. It involves the financial fallout that happens long after the child support is settled. It's about the hidden assets, the disputed gifts, and the way the American taxman views a religious dowry. In the next part, we are going deep into the financial warfare of Islamic divorce in the U.S. We will explore how hidden bank accounts, international properties, and the IRS interact with the Mahr. You will see why a $50,000 promise made at a wedding in 2018 can lead to a federal investigation in 2026. Stay tuned for Part 5. In 2026, the financial dissolution of an American Muslim marriage has become a masterclass in what sociologists call high-stakes navigation. We are no longer just talking about splitting a bank account or deciding who keeps the car. We are looking at a collision between the Islamic principle of absolute separate property and the American legal doctrine of equitable distribution or community property. To understand the gravity of this, we have to look at the financial life cycle of a couple we will call James and Layla. When they married in 2018, they signed a nikah contract that included a mahr or dower of $50,000, with $10,000 paid up front and $40,000 deferred until divorce or death. At the time, it felt like a symbolic religious gesture. But as they stand in a divorce court in 2026, that piece of paper has become a central piece of evidence in a complex financial war. From a sociological perspective, the Islamic economic model is one of radical individualism within a marriage. Under Sharia, Layla's income from her job as a senior consultant is hers and hers alone. She has no religious obligation to spend a single penny on the mortgage, the groceries, or James's student loans. James, conversely, is religiously mandated to provide for every single household necessity. However, in the United States, most states operate under equitable distribution. This means that any wealth created during the marriage is considered marital property, regardless of whose name is on the paycheck. This creates a sociological friction point. If Layla has been saving 30% of her income in a separate high-yield savings account for 8 years, believing it is her divinely protected property, she is in for a shock when a U.S. judge rules that James is entitled to half of it. This leads to the phenomenon of asset shielding, a trend sociologists are documenting with increasing frequency in 2026. Because of the perceived injustice of civil law overriding religious property rights, some individuals may attempt to move assets into the names of extended family members or into international accounts. This is where the IRS and forensic accounting enter the picture. Case studies from 2025 show that the IRS has become increasingly sophisticated at tracking what they call informal value transfer systems. If James claims he has no savings, but forensic accountants find a series of wire transfers to a cousin in Jordan or a sudden spike in gold purchases, the legal consequences move from family court into the realm of federal oversight. In the American sociological view, this is seen as a breakdown of financial transparency, but within the community, it is often framed as a desperate attempt to adhere to a religious property regime that the state refuses to recognize. The Mahr itself is the ultimate legal landmine. In 2026, the potential outcomes for a Mahr dispute in a U.S. court are wildly inconsistent. In some jurisdictions, judges treat the nikah as a valid prenuptial agreement, provided it meets the criteria of full disclosure and lack of duress. In others, it is dismissed as a religious gift that is unenforceable in a secular court. Imagine the sociological impact on Layla if she relied on that $40,000 deferred MAR as her safety net, only to have a judge rule it invalid. Conversely, imagine James, who is already being ordered to pay 50% of his assets to Layla under civil law, being told he must also pay an additional $40,000 because of the religious contract. This is what sociologists call double dipping, and it is a primary source of bitterness in modern American Muslim divorces. Historical trends suggest that the way gold is handled is another massive sociological outlier. In many Muslim cultures, jewelry given to the bride is not just an accessory. It is a portable, liquid form of economic capital. In a 2026 divorce case, the valuation of this gold can be a flashpoint. If Layla was given $100,000 worth of 24-karat gold during the wedding, a U.S. court might see this as a marital asset to be appraised and split. However, sociologically and religiously, that gold is often viewed as her exclusive property, a form of insurance against the husband's power of divorce. When a husband's attorney demands that the gold be placed on the table for distribution, it is often perceived as a violation of a sacred financial boundary. This has led to the rise of specialized appraisers in metropolitan areas like Houston and Chicago, who specifically handle the valuation of high-purity gold for Islamic divorce settlements. Then there is the issue of transnational real estate. Many American Muslim families in 2026 hold property in their countries of origin, apartments in Cairo, land in Lahore, or villas in Istanbul. Under U.S. law, a judge can take the value of that international property into account when dividing the domestic assets. If James owns an apartment building in Dubai worth $500,000, the court might award Layla a larger share of the family home in Virginia to offset that value. The sociological challenge here is one of verification. How does a U.S. court accurately value a plot of land in a rural village 3,000 miles away? This creates a massive power imbalance. A party with more knowledge of the international assets can use that information as a weapon of coercion, leading to settlements that are legally binding but sociologically viewed as exploitative. We must also address the sociological concept of financial coercion as a tool of religious negotiation. In 2026, we see cases where a husband might agree to a favorable civil settlement only if the wife waives her right to the MAR or agrees to a specific religious custody arrangement. This is a form of shadow bargaining. The legal system sees a signed agreement, but the sociological reality is one of immense pressure. The threat of withholding a religious divorce, as we discussed in the previous part, is often tied directly to these financial demands. It is an intricate dance of leveraging one system against the other. Data from the 2025 North American Muslim Financial Survey indicates that second-generation couples are increasingly moving away from these traditional conflicts by using Islamic wills and secular prenuptial agreements that are explicitly designed to mirror one another. They are essentially creating a third legal reality that bridges the gap. These couples are hiring dual-qualified experts who understand both the Internal Revenue Code and the intricacies of fiqh, or Islamic jurisprudence. The potential outcomes for these prepared couples are much more stable, but they represent a small, affluent minority of the community. As we move into the next phase of this deep dive, we have to look at the psychological and social fallout of these financial battles. When the money is gone and the court orders are signed, the individuals don't just disappear. They have to live in a community that has watched the entire drama unfold. In 2026, the village square has been replaced by the smartphone screen. The next part of our masterclass will explore the devastating and transformative power of the court of public opinion. We are going to look at how social media, mosque politics, and digital reputation management are the new frontiers of divorce. What happens when your private heartbreak becomes a viral thread? We are going to examine the rise of digital shaming and the sociological impact of the cancel culture within the American Muslim community. You will see how a single Instagram post can change the outcome of a divorce faster than any lawyer. Stay tuned for part 6. In 2026, the traditional concept of the village square has been replaced by a digital panopticon. For American Muslims navigating divorce, the sociological impact of this shift is profound. We are seeing the emergence of what researchers call digital honor culture. Historically, a divorce was a localized event, contained within the immediate family or a single congregation. Today, the details of a marital breakdown can traverse the global ummah in seconds. This creates a high-stakes environment where reputation management becomes as critical as legal strategy. To understand this, let's look at a case study involving two characters we will call Mark and Sophia. Imagine if Mark is a well-known community organizer in Northern Virginia, And Sophia is a popular lifestyle influencer with a significant following on platforms like TikTok and Instagram. When their marriage begins to fail in 2026, the divorce is not just a private dissolution, it is a brand crisis. From a sociological perspective, their marriage functioned as a form of social currency. Their followers were invested in their image of a modern, pious, and successful American Muslim couple. When the separation is announced, the community does not just offer sympathy. It begins to take sides in what is effectively a digital trial. Historical trends show that in the early 2020s, public callouts were often seen as a last resort. By 2026, they have become a primary tool of negotiation. Sophia, feeling that Mark is being unfair in the civil property division, might post a series of vague, cryptic stories about integrity and the rights of women in Islam. She doesn't have to name Mark, the community fills in the blanks. This is the subtle post, a sociological maneuver designed to build a narrative of victimhood and mobilize social support before the legal battle even hits its peak. Sociologists call this narrative priming. By the time the case reaches an imam or a judge, the court of public opinion has already reached a verdict. Step by step, we see how this digital pressure influences the potential outcomes of the divorce. If Mark's professional life depends on his reputation for being a man of character, Sophia's digital influence acts as a sword. If he refuses to grant a religious divorce or contests the mahr, Sophia's supporters might initiate a boycott of his business or pressure the organizations he works with to distance themselves. In 2026, we are documenting a rise in digital shaming as a mechanism for forcing compliance with religious norms. It is a decentralized, often unregulated form of vigilante justice. While it can empower the vulnerable, it also risks creating a culture of mob rule where nuance is sacrificed for viral engagement. The sociology of ghiba, or backbiting, has undergone a radical transformation in this environment. Traditionally, speaking ill of a former spouse was strictly prohibited in Islamic ethics. However, in the 2026 digital landscape, many justify these public disclosures under the guise of awareness or protecting other sisters. This shift is creating a psychological schism. Data from a 2025 study on Muslim mental health indicates that individuals going through a public divorce in the U.S. report higher levels of social anxiety and isolation than those in the general population. The fear is not just the loss of a spouse, but the permanent, searchable record of their personal failures. In the age of AI and deep search indexing, a divorce threat from 2026 could still be the first thing a potential employer or future spouse sees in 2036. Now let's look at the influencer factor from a different angle. Imagine if Mark is the one with the platform. He might use his reach to frame the divorce as a consequence of Sophia's lack of traditional values, tapping into a growing manosphere sentiment within certain segments of the community. This creates a sociological echo chamber. Each party retreats into a digital tribe that reinforces their version of the truth. This tribalism makes mediation nearly impossible. An imam attempting to reconcile the couple in 2026 is no longer just talking to Mark and Sophia. He is competing with the voices of thousands of strangers in their comment sections. This is the phenomenon of crowdsourced conflict. We must also consider the role of WhatsApp and Discord. While Instagram is the public stage, the real sociological warfare happens in the private groups. In 2026, every major U.S. mosque has dozens of unofficial, splintered WhatsApp threads. When a divorce occurs, these groups become the breeding ground for misinformation. Leaked court documents, screenshots of private texts, and audio recordings are shared with a speed that the legal system cannot match. This creates a state of perceptual distortion. The community members feel they have insider information, leading to a fragmentation of the social fabric. A person might be welcomed in one mosque but find themselves whispered about and excluded in another, based entirely on which WhatsApp group the local leadership belongs to. The potential outcomes of this digital environment are forcing a change in how divorce is handled by religious authorities. In 2026, some Sharia councils in the U.S. have begun to include social media clauses in their mediation agreements. These clauses are essentially non-disparagement agreements tailored for the religious community. They might state that any public posting about the divorce proceedings will result in an automatic financial penalty or a forfeiture of certain religious claims. This is a fascinating sociological attempt to reestablish the boundaries of privacy in an era that has largely abandoned them. However, there is a shadow side to this digital revolution. For those without a platform, the marginalized, the immigrants, those without high-tech literacy, the digital divide creates a new form of vulnerability. Imagine a woman who has recently arrived in the US, has no social media presence, and is being divorced by a husband who is a tech-savvy community leader. He can shape the entire narrative of their separation before she even understands how to use the apps. Sociologists call this informational asymmetry. In 2026, the ability to control the digital narrative is a form of power that is just as significant as financial or legal resources. Data from the 2025 American Muslim Social Trends Report suggests that this digital landscape is leading to a rise in secretive divorces among the elite. To avoid the digital panopticon, wealthy or high-profile couples are opting for hyper-private, out-of-court settlements with strict NDAs, effectively opting out of the community's social and religious oversight altogether. This creates a two-tiered sociological system: a public, messy digital theater for the masses and a private, shielded exit for the powerful. As we analyze these digital battles, we realize that they are often a proxy for a much older and deeper power struggle. Behind every Instagram post and every viral thread, there is a hidden army of influencers who don't use smartphones but wield more power than any algorithm: the extended family. In 2026, the in-law factor remains the single most powerful predictor of whether a divorce will be a peaceful transition or a total war. In the next part of this masterclass, we are going into the heart of the multi-generational conflict. We will look at how the shadow government of aunts, uncles, and grandparents can make or break a divorce settlement. We will explore the sociology of family honor and why, in 2026, the biggest obstacle to a fair divorce isn't the husband or the wife. It's the person sitting at the head of the dinner table. Stay tuned for Part 7. In the year 2026, as we walk into a high-end suburban home in Irvine, California, or a multi-generational brownstone in Brooklyn, the sociological reality of an American Muslim divorce often reveals a hidden layer of governance that no civil court or state statute acknowledges. This is the shadow government of the extended family. To truly understand the sociological views on divorce in Islam within the United States today, we have to move past the husband and the wife and look at the person sitting at the head of the dinner table. In many immigrant-descended communities, marriage is not a bilateral contract between two autonomous individuals. It is a multilateral treaty between two sprawling kinship networks. When that treaty begins to crumble, the fallout is not just personal, it is structural. Consider the case study of Omar and Miriam. In early 2026, after 6 years of marriage, they find themselves at a crossroads. Under the surface, the reasons for their potential separation are familiar: communication breakdown, differing views on career growth, and the slow erosion of intimacy. However, in their community, the decision to finalize a divorce is not theirs alone. Sociologically, they are subject to the concept of collective accountability. In many American Muslim enclaves, the family's reputation, or izzat, is a form of social capital that is traded, earned, and lost collectively. If Miriam pursues a divorce, she is not just ending her relationship with Omar. She is perceived as devaluing the social currency of her father, her brothers, and even her unmarried cousins. Historical trends in the U.S. diaspora suggest that the pressure to stay in an unhappy or even dysfunctional marriage often comes from the fear of a status collapse. For Miriam's father, a respected physician and a donor to the local Islamic center, her divorce is seen as a public admission of a failure in his household's governance. From a sociological perspective, this is structural functionalism in its most rigid form. The family is the primary unit of the community, and any crack in that unit is seen as a threat to the stability of the entire mosque ecosystem. In 2026, we are seeing a fascinating tension between the second generation's desire for individual happiness and the first generation's obsession with communal perception. Imagine if Miriam's mother-in-law, Mrs. Siddiqui, holds the keys to the couple's financial stability. In many high-net-worth American Muslim families, wealth is not individual but familial. The down payment on Omar and Miriam's house may have come from Omar's parents, and the title might still be in his father's name. This creates a state of economic entrenchment. When divorce is mentioned, the threat of being cut off from the family inheritance or being evicted from the family-owned home becomes a powerful deterrent. Sociologists call this coercive interdependence. The potential outcomes of a divorce in this scenario are often dictated by who controls the family trust, rather than what the civil court might rule. In 2026, we are documenting a rise in legal cases where U.S. judges are struggling to untangle these informal family loans and gift deeds that were never intended to be scrutinized by a secular court. The role of the in-law interference is perhaps the most cited sociological factor in the breakdown of American Muslim marriages. In 2026, The traditional power dynamic where a bride moves into the groom's family home has largely shifted toward independent living. Yet the psychological proximity remains. Through constant digital connection, WhatsApp groups, FaceTime, and shared calendars, the extended family remains a third party in the bedroom. Case studies show that many divorces are triggered not by the spouse's behavior, but by the perceived failure of the spouse to set boundaries with their own parents. This is the boundary paradox. In Islam, honoring one's parents is a divine mandate, yet protecting one's spouse is a legal obligation. When these two collide in a 2026 American context, the result is often a sociological stalemate that leads directly to the divorce attorney's office. We also have to analyze the concept of ghera, or protective honor. While often discussed in theological terms, its sociological application in 2026 is a tool of social control. If a husband is seen as too lenient or if a wife is seen as too independent, the extended family may exert pressure to correct the behavior to save the family's face. When a divorce becomes inevitable, this ghera often transforms into litigious aggression. The family that was once the couple's biggest support system becomes their most formidable opponent in court. In 2026, we see grandmothers and aunts acting as the primary strategists in custody battles, viewing the children not just as grandchildren, but as the final remnants of the family's genetic and cultural legacy that must be won at all costs. However, a new sociological shift is emerging in 2026: the rise of the allied elder. We are beginning to see a small but significant trend of first-generation parents who, having witnessed the devastating impact of toxic marriages on their children, are now the ones advocating for divorce. These elders are utilizing their social capital to shield their children from community gossip. This is a form of internal reform. When a respected patriarch stands up at a community event and says, "My daughter is divorced, and we are proud of her courage," the sociological weight of the stigma is cut in half instantly. This validation from the top is the most effective tool for social change within the community, far more powerful than any academic lecture or viral video. Step by step, the family's involvement in the divorce process in 2026 follows a predictable sociological pattern. First, there is the internal silence, where the couple hides the struggle to protect the family's peace. Second is the explosion, where the secret is revealed, often through a crisis. Third is the mobilization, where aunts, uncles, and elders descend to mediate, often with a bias toward maintaining the status quo. Finally, there is the fragmentation, where families are forced to choose sides, leading to the shadow judiciary, decisions we discussed in earlier parts. The data suggests that marriages where the extended family is integrated but disciplined, meaning they provide support without overstepping, have the highest survival rates. But in the high-pressure environment of 2026 America, that balance is becoming increasingly rare. What happens to the individual when they are caught between the hammer of family honor and the anvil of personal despair? The psychological toll of navigating these multi-generational expectations is immense. We are seeing a hidden epidemic of mental health struggles that the community is only just beginning to name. As we look at the wreckage of these family battles, we have to ask, what is the cost of saving face when the price is the mental well-being of the next generation? In the next part of this masterclass, we are going deep into the psychological landscape of divorce. We will explore the silent trauma, the rise of divorce depression in the masjid, and how the 2026 American Muslim community is finally breaking the taboo on therapy. You will see why the most important healing doesn't happen in a courtroom or a mosque, but on a therapist's couch. Stay tuned for Part 8. The transition from the legal and financial battlegrounds of divorce into the internal psychological landscape is perhaps the most daunting phase for any individual in the American Muslim community in 2026. For decades, the sociological view on mental health within this demographic was one of hushed tones and redirected advice. If you were struggling in your marriage, you were told to increase your prayers or exercise more patience. But as we stand here in 2026, the data indicates a massive paradigm shift. Sociologists are now documenting what is called the Great Unveiling of Muslim mental health. The taboo is not just cracking. It is being dismantled by a generation that views therapy as an essential component of their religious obligation to maintain the self. To understand the psychological weight of an Islamic divorce in a U.S. context, we must first look at the concept of spiritual gaslighting. This is a term that has gained significant sociological traction in 2026. It refers to the practice of using religious texts or concepts to invalidate a person's legitimate emotional or physical suffering. Imagine a character named Adam living in a suburb of Dallas. Adam is 35, a successful civil engineer, and a father of 2. For years, Adam has been in a marriage characterized by profound emotional neglect and high conflict cycles. When he approached his community elders in the past, he was often met with the phrase, "Sabr is the key to paradise." From a sociological perspective, this use of sabr or patience was historically applied as a tool for social preservation rather than individual well-being. In 2026, however, Adam's story takes a different turn. He represents the new historical trend where the individual refuses to accept suffering as a divine mandate. The psychological fallout of a divorce in this community often begins with an identity crisis. In many Islamic teachings, marriage is famously described as completing half of one's faith. Sociologically, when that marriage ends, many individuals experience a sensation of being halved. They feel they have not only failed their spouse and their family but that they have somehow become less of a believer. This leads to a specific type of depression that therapists in 2026 are calling religious ego dissolution. It is the crushing weight of feeling that your spiritual standing is tied directly to your marital status. Case studies from mental health clinics in Michigan and California show that the first 6 months post-divorce are the most critical for American Muslims. During this time, they often face what is known as social dislocation. Imagine if Adam's entire social life was built around the local mosque. His friends are the husbands of his wife's friends. Their children play together. When the divorce is finalized, Adam finds himself effectively exiled from this network. Not because he is banned, but because the community lacks a sociological blueprint for how to integrate a divorced man. He is no longer part of the couple's dinners or the family outings. This isolation triggers a biological stress response that, if left untreated, leads to chronic anxiety and a total withdrawal from religious life. This is where the 2026 movement toward culturally competent therapy becomes a lifesaver. We are seeing the rise of the Islamic integrated mental health model. This isn't just standard talk therapy. It is a sophisticated blending of cognitive behavioral therapy with Islamic principles of nafs, or the self. In 2026, Adam doesn't just go to any therapist. He seeks out a licensed professional who understands that his guilt is tied to his theology. The therapist helps him reframe the divorce not as a spiritual failure, but as a legitimate legal and personal boundary. They look at historical trends of the Sahaba, the companions of the Prophet, who divorced and remarried without the crushing stigma that exists today. This is the sociological act of reclaiming the narrative. By using the faith's own history to validate their current pain, American Muslims are finding a path to healing that doesn't require them to leave their identity at the door. Step by step, the psychological recovery process in 2026 involves 3 distinct phases. The first is delinking. This is the process of separating one's worth from the success of the marriage. It requires intense work to overcome the internalized shame that has been baked into cultural upbringings. The second phase is community reentry. This is where the sociological view shifts from the individual to the collective. In 2026, we are seeing the emergence of divorce support groups within mosques. These are safe spaces where individuals like Adam can realize they are not alone. Data suggests that participation in these groups reduces the potential outcomes of long-term clinical depression by nearly 50%. It provides a new social anchor that replaces the one lost during the split. The third phase is the navigation of the next generation's trauma. We cannot talk about the psychology of divorce without talking about the children. In 2026, the American Muslim community has largely moved away from the stay together for the kids mentality, recognizing that a high-conflict home is more damaging than a peaceful split home. However, the children still face a unique sociological challenge: the conflict of loyalties. In a community that prizes family unity above all else, children often feel they must choose a side to maintain their sense of safety. Sociologists are now advocating for mandatory co-parenting therapy as a part of the religious divorce decree. This is a structural intervention designed to break the cycle of intergenerational trauma. Furthermore, we must address the gender differences in psychological recovery. While men like Adam often face social isolation, women in the 2026 American Muslim community frequently face a different psychological hurdle: hypervigilance. Due to the digital shaming and social scrutiny we discussed in earlier parts, many divorced women live in a state of constant fear regarding their reputation. This leads to a performance of piety, where they feel they must be twice as observant and twice as perfect to avoid the stigma of being a divorcee. The psychological cost of this performance is exhaustion and a loss of authentic self. Sociologists are calling for a grace-based community model to alleviate this pressure, emphasizing that a woman's worth is not determined by her marital history. As we look at the data from early 2026, the potential outcomes for those who engage in this deep psychological work are incredibly promising. We are seeing a phenomenon called post-traumatic growth. Many individuals emerge from the divorce with a stronger, more personal relationship with their faith, no longer mediated through a spouse or a set of cultural expectations. They become the leaders of a more empathetic and nuanced community. They are the ones who will mentor the next generation on how to build healthier marriages from the start. But even as the mind begins to heal and the individual finds their footing, a new and perhaps even more complex challenge emerges on the horizon. The human heart does not stay closed forever. In 2026, the question for the American Muslim divorcee eventually becomes, what now? This leads us into the high-stakes, often chaotic, and deeply controversial world of the second chance. In the next part of this masterclass, we are diving into the Wild West of the 2026 Muslim dating and remarriage scene. We will explore the app culture, the second marriage stigma, and how the search for love after divorce is forcing a total rewrite of the community's social rules. You will see why the road to a second nikah is often more difficult than the road to the first. Stay tuned for Part 9. The transition from the finality of a divorce decree to the tentative first steps of re-entering the matrimonial market in 2026 is what sociologists call the halal dating renaissance. This is not the courtship of the early 2000s, nor is it the arranged introductions of the 1990s. For the American Muslim divorcee, the search for a second chance is a high-tech, legally cautious, and sociologically complex journey that is rewriting the rules of engagement. To understand the gravity of this shift, we must look at the data. Historical trends leading up to 2026 show that while divorce rates have stabilized, the interval between divorce and remarriage has shortened, largely due to the hyper-efficiency of digital matchmaking specifically calibrated for the Muslim diaspora. Imagine Nora, a 34-year-old graphic designer in Chicago. She finalized her divorce in 2024 and has spent 2 years in the psychological recovery phase we discussed in the previous part. Now in 2026, she opens a matrimonial app. But this isn't just any app. It is a specialized 2026 iteration of platforms like Muzz or Salams that features AI-driven personality matching and, most importantly, verified marital history badges. From a sociological perspective, Nora is navigating the commodification of her marital status. In the past, being a divorcee was a scarlet letter that she might try to hide until the third or fourth meeting. In 2026, it is a data point on her digital profile, filtered for by some and sought after by others. This brings us to the social exchange theory. In the sociological view of the 2026 marriage market, individuals bring certain assets to the table. For a first-time bride, that asset was often framed through the lens of youth or purity. For a divorcee like Nora, the market value has shifted toward emotional intelligence, financial independence, and a proven ability to manage a household. However, the potential outcomes of this shift are not always egalitarian. Data from the 2025 North American Muslim Matrimonial Survey indicates a persistent double standard. Divorced men are significantly more likely to find a spouse who has never been married before, while divorced women are largely funneled toward other divorced men or widowers. Sociologists call this the reciprocity of status, and in 2026, it remains one of the most stubborn remnants of traditional hierarchy within the American Muslim community. However, Nora has a legal and theological advantage that she didn't have the first time: the status of the thayyib. In Islamic jurisprudence, a woman who has been previously married gains a significantly higher degree of legal autonomy regarding her next marriage. While a first-time bride, a biker, traditionally requires a wali or male guardian to enter into a contract, many schools of thought grant the thayyib the right to represent herself. In the American sociological context of 2026, this is a revolutionary shift in power. Nora is no longer a passenger in her own marriage negotiations. She is the lead negotiator. Step by step, the 2026 remarriage process for a divorcee involves a much more rigorous vetting phase. Because they have already seen the potential outcomes of a failed contract, second-timers are utilizing what sociologists call radical transparency. In Nora's first marriage, the mahr was a symbolic gesture. In 2026, As she meets potential suitors, the conversation about the mahr is treated like a corporate merger. She is likely to demand a higher deferred mahr as a form of insurance, and she is almost certain to insist on a civil prenuptial agreement that mirrors the Islamic contract. Case studies from 2025 suggest that second marriages in the American Muslim community have a statistically higher success rate than first marriages, precisely because the participants are entering them with their eyes wide open to the sociological and financial realities of the union. But what happens when children are involved? This is where we encounter the sociological complexity of the blended family. Imagine if Nora's new partner, let's call him David, a 38-year-old physician who is also divorced, has 2 children of his own. In 2026, the Brady Bunch of the American masjid is becoming a common sociological unit. However, merging these households requires navigating the intricate laws of nafaka, maintenance, and mahram, unmarriageable kin status. Under Islamic law, David is not financially responsible for Nora's children from her previous marriage. Their biological father is. Conversely, Nora's children must navigate their relationship with David through a specific religious lens. Sociologists are documenting a rise in blended family mediation, a new professional niche where counselors help couples navigate the potential outcomes of my kids versus your kids in a religious framework. The convert factor is another major historical trend in 2026. A significant percentage of divorced American Muslim women are choosing to remarry converts to the faith. From a sociological standpoint, this is a strategic move to bypass the cultural baggage of the divorcee stigma prevalent in some ethnic enclaves. A convert often comes with what sociologists call a tabula rasa, a clean slate. They lack the ingrained cultural biases against divorced women and are often more focused on the theological principles of the faith rather than the social gossip of the community. This trend is creating a new vibrant subculture within the U.S. Ummah that is redefining what a traditional family looks like. We also have to analyze the role of the new in-laws. In 2026, the parents of a divorced individual are often much more cautious. They have seen their child suffer, and they are less likely to prioritize family honor over their child's safety. This leads to a sociological phenomenon known as protective gatekeeping. When Nora introduces David to her parents, the interrogation is no longer about his family's lineage or the prestige of his degree. It is about his conflict resolution skills and his views on domestic equity. The shadow government of the extended family, which we discussed in Part 7, is beginning to pivot from a force of control to a force of vetting. The 2026 search for love after divorce is also being shaped by a movement called ethical courtship. Disillusioned by the ghosting and breadcrumbing of secular dating apps, divorced American Muslims are leading a return to chaperoned or community-witnessed interactions, but with a modern twist. They use digital chaperones, third parties in a group chat or AI-monitored platforms that ensure the conversation stays respectful and focused on the goal of marriage. This is a fascinating blend of ancient modesty and futuristic technology, designed to protect the individual's emotional and spiritual heart from the burnout culture of modern dating. As we look at the data from the first half of 2026, we see that the American Muslim divorcee is no longer a figure of pity. They are becoming the community's most sophisticated social architects. They are the ones demanding better contracts, healthier boundaries, and more authentic connections. They are proving that a divorce is not the end of a story, but the necessary clearing of the ground for a more stable structure to be built. But as the individual finds their new partner and the blended families begin to take shape, we are forced to zoom out. We have looked at the law, the money, the kids, and the search for love. Now we must face the macro picture. How is this cycle of marriage and divorce changing the very face of Islam in America? What does the post-divorce community look like? And is the traditional mosque prepared for the reality of 2027 and beyond? In the final part of this masterclass, we are bringing it all together. We will explore the sociological future of the American Muslim family, the death of the taboo, and the ultimate synthesis of how a community finds strength in its broken pieces. The conclusion to this deep dive is the most important part of the journey. Stay tuned for Part 10. As we stand at the final threshold of this deep dive masterclass in 2026, we have moved through the corridors of ancient law, the high-stakes arenas of American courtrooms, and the intimate, often painful transformations of the human heart. But to truly synthesize the American sociological view on divorce in Islam, we must look at the macro-level transformation of the community itself. What we are witnessing in 2026 is not the erosion of a religious community, but what sociologists are calling the Great Integration. This is the moment where the friction between a 1,400-year-old legal tradition and a 250-year-old secular republic finally produces a new, resilient social fabric. The taboo of divorce is not just dying. It is being replaced by a sophisticated, service-oriented model of community life that prioritizes social health over silent suffering. Imagine a community center in 2026, perhaps in the suburbs of Dallas or the urban heart of Chicago. In previous decades, the family hall of the local mosque was used almost exclusively for nikah ceremonies and celebrations. Today, that same space is the site of the divorce transition workshop. This is a structural functionalist dream. The institution has adapted to a new reality to maintain its relevance. These workshops, now a standard feature in major U.S. metropolitan areas, don't just provide spiritual consolation. They offer a multidisciplinary approach. On Monday, a family law attorney explains the nuances of equitable distribution. On Wednesday, a licensed clinical social worker discusses the trauma of displacement. And on Friday, an imam provides a theological framework for starting over with ihsan, or excellence. Historical trends from the early 2020s showed a community in crisis, struggling to hide its rising divorce rates. By 2026, the data indicates that mosques which have embraced this transparency have seen a 40% increase in the retention of younger, college-educated congregants. This is the sociological principle of institutional legitimacy. When a community acknowledges the messy reality of its members' lives, it gains their trust. This shift is creating a new demographic within the American Muslim population: the empowered single parent. In the past, a divorced mother might have felt like a peripheral figure in the masjid. In 2026, she is often at the center of community leadership, utilizing her lived experience to build more robust social safety nets. Let's look at a case study involving a character we will call Kevin. Kevin is a 42-year-old convert to Islam who finalized his divorce in late 2025. In 2026, Kevin represents a new historical trend: the rise of the vulnerable patriarch. Kevin leads a monthly circle for divorced Muslim men. In these meetings, the conversation isn't about maintaining control or honor in the traditional sense. Instead, it is about navigating the psychological potential outcomes of a split household. They discuss how to be an active, present father while living in a separate residence, and how to heal from the ego wound of a failed marriage without falling into the manosphere rhetoric that often targets frustrated men. From a sociological perspective, Kevin and his peers are redefining masculinity in American Islam. They are moving away from a model of dominance toward a model of responsibility and resilience. This transformation is having a profound effect on zakat distribution and community economics. In 2026, we are seeing the professionalization of mosque-based charity. Instead of just giving a one-time check to a struggling divorcee, zakat committees are now investing in transition grants. These are structured financial supports designed to prevent the feminization of poverty that often follows divorce. Case studies from organizations like the National Zakat Foundation of America show that providing 3 months of rent, legal fee assistance, and job retraining for divorced women leads to long-term economic stability. This is the sociological theory of social investment. The community has realized that supporting a divorcee is not an act of pity. It is an act of preserving the human capital of the Ummah. We must also analyze the global ripple effect. What is happening in the United States in 2026 is being watched closely by sociologists in London, Toronto, and even Kuala Lumpur. The American Muslim experience is unique because it lacks a state-sponsored religious hierarchy. This has forced a decentralized innovation. When an American woman successfully uses a delegated divorce clause in her nikah to free herself from a toxic situation, it becomes a blueprint for women in other Western democracies. We are seeing a transnational exchange of legal best practices. The potential outcomes of this are immense. A global modernization of Islamic domestic law, driven not by government decrees, but by the grassroots demands of a literate and empowered diaspora. However, a remaining sociological challenge in 2026 is the generational synthesis. While the younger generation has embraced these changes, there is still a segment of the elder population that views the normalization of divorce with deep skepticism. They fear that by making divorce easier or less shameful, the community is encouraging the individualist decay of the West. Sociologists call this the traditionalist guardrail. In 2026, the most successful communities are those that bridge this gap. They honor the elders' commitment to family stability, while acknowledging the younger generation's commitment to individual safety and justice. It is a delicate dance of continuity and change. Step by step, we have seen how the American Muslim community is moving toward a state of pragmatic pluralism. They are no longer asking, "How can we stop divorce?" They are asking, "How can we ensure that when divorce happens, it is handled with the highest level of justice, psychological support, and financial fairness?" This shift from prevention to management is the ultimate sign of a community that has matured within the American pluralistic landscape. They are taking the best of Islamic ethics, the mandate for mercy and justice, and the best of American systems, legal transparency and mental health advocacy, and creating something entirely new. As we conclude this deep dive masterclass, we see that the American sociological view on divorce in Islam is a story of incredible resilience. It is a story of a community that was forced into the shadows by stigma and came out into the light with a better version of itself. The broken pieces we discussed at the beginning are being reassembled into a mosaic that is stronger because of its cracks. The 2026 American Muslim family is not a fragile relic of the past. It is a dynamic, evolving unit that is capable of navigating the complexities of the modern world without losing its spiritual compass. This concludes our 10-part series on the sociological evolution of the American Muslim family. We have covered the legal frameworks, the financial landmines, the battle for the children, the digital revolution, and the psychological healing. But the story of the 2026 community doesn't stop here. While we have mastered the end of the marriage, a new and perhaps even more controversial topic is emerging on the horizon. It involves the very beginning of the social contract. What happens when the AI matchmaking we discussed earlier meets the ethical courtship movement? We are preparing a new deep dive investigation into the algorithmic nikah, the future of marriage in the age of Silicon Valley. If you thought the divorce battle was intense, wait until you see how the next generation is being coded for companionship. We will see you in the next series.